moderate the last part of this workshop. It's time to listen Alexander Vargas, who visits us of Universidad, Externado de Colombia. He had prepared the presentation entitled "The Blurred Contours of Fundamental Right to Reparation in Colombia." Your time, Alex.
Thank you, Sydney, for this presentation, and thanks to the Network of Philosophy of Private Law for this invitation also. I'm really grateful for this invitation, and grateful to the University of Girona for hosting this workshop. I will present the current state of the ruling of the Colombian Constitutional Court regarding the essential content or essential core of the fundamental right to reparation or comprehensive reparation. In Colombia, it is said that this right is a right to a restitutio in integrum that a person must receive not only as compensation for the inflicted harm, but also other measures, monetary or not, that aim to return the situation as if the harm never had happened. In the first part, I will extract three theoretical indeterminacies that seem evident to me in the arguments exposed in this court. Then, in the second part, I will propose what could be considered some elements to determine the essential content of that right. I will conclude by adopting a skeptical position regarding the possibility of an accurate determination of the essential content of this right before the examination of the cases where the right is protected. A brief explanation of the Constitutional Court rule will help us to understand the matter that I am presenting here. According to our Constitution, our Constitutional Court decides about the public legal action that any person may present against a law or part of it when they consider that its content is contrary to the Constitution. Judgments issued by the court in this regard are binding with erga omnes effects. Hence, in judgment C-344 of 2017, the court examined the claim of unconstitutionality that was filed against the phrase material and moral contained in Article 94 of the Criminal Code concerning the reparation of harm derived from criminal conduct. Here, it is critical to make a clarification because the name moral damages is used in our civil tradition to refer to the monetary compensation that the victim who has suffered harm against non-pecuniary interest receives. This is the case, for example, when somebody had emotional suffering and distress produced by the death of their loved ones. After this clarification is made, according to the plaintiff, Article 94 violated the Constitution because it limited the reparation of damages only to those that the case law of the Supreme Court and the Council of State had named as material and moral damages, leaving out the reparation of other non-pecuniary damages, such as damages recognized for the harm to relationships or damages for the violation of constitutional rights. The court decided to declare that such part of the article conformed to the Constitution as long as it was understood that the sentence used was merely enunciative and not exhaustive. That is, that all the damages that were caused by crimes and proven during the process should be repaired. In addition, in that judgment, it is reiterated until now that the essential core of the right to reparation was discussed. According to this doctrine of the essential content or essential core, while one may interfere with the periphery of a right to realize a competing one, no limitation of the core would be constitutionally acceptable. In other words, there is a part of the content of right that is unavailable to the legislator, so it is beyond its jurisdiction to modify that content without violating that core or essential content. Regarding the right to a restitutio in integrum or a comprehensive reparation, the court said the following. First, the legislator may limit the fundamental right to comprehensive reparation because it is not an absolute right. Second, there is no constitutional mandate that determines the content of comprehensive reparation. Third, the legislator has in this matter a margin of configuration to determine the reparable damages. Regarding the possibility of the legislator to delimit the right, the court stated that, 4, Notwithstanding, the legislative measure that delimit the right to comprehensive reparation must be reasonable and proportionate, while they cannot affect the essential core of the right itself, which implies the possibility of reparation by pecuniary and non-pecuniary means, all the damages that are proven regardless of their name or legal qualification. 5, and finally, these limitations are only predicable of pecuniary reparation measures, but do not exclude non-pecuniary measures that have been recognized as constitutionally enforceable forms to achieve comprehensive reparation, that is, restitution, rehabilitation, satisfaction, and guarantees of non-repetition, to refer to in this ruling. This thesis has been reiterated on several occasions until now, and it appears that it reflects the position of the High Court on this point. In this regard, I will point out 3 uncertainties that show that the core of essential content is not clear at all. The first one is an indetermination of the entitlement of the fundamental right. It seems to me that there is a lack of certainty regarding who is entitled to the right to comprehensive reparation, as it has been characterized by that essential core. Most of the rulings that have been issued about the essential core of the right to reparation are related to criminal or transitional justice norms that involve the violation of human rights within those respective branches of the legal system. These circumstances raises doubts about the scope of this right with respect to the reparations that are ordered outside of such areas, as would be the case of tort law and labor law, among others. The pertinent question here is whether this essential content belongs only to the right to reparation of victims of crime or violation of fundamental rights, or whether a victim of harm not derived from a crime has a right with the same characteristics. In other words, it is not clear that the right to reparation is a right only of those who have suffered harm by criminal conduct or for any victim of wrongful harm. It is important to say that there have been many legal decisions in which courts talk about a comprehensive reparation regardless of the existence of a crime against the victim. A second indeterminacy is about the limits of legislative configuration, and maybe this is the most important indeterminacy here. And it's evident in the statements about the limits of the legislative power with respect to this right. In particular, the vagueness of the court's statement regarding those limits makes it difficult to determine its essential content. For example, the court affirms that the legislator can establish limits to pecuniary and non-pecuniary reparations without saying beyond such limitation must be proportional or reasonable. Of course, to determine what is proportional or reasonable, another principle must be taken into account. So the idea of essential content is not sufficient in itself to determine what is proportional or reasonable. I consider that these legislative limitations are necessary and not optional. On the other hand, if all the damages that are proven should be repaired, then it would not be true that the legislator has in this matter a margin of configuration to determine the reparable damages, because it would not be possible to not repair all damages that were proven in the legal process. So it seems to me that the limitations to the right to reparation are not an optional matter of the legislator, but necessary for the realization of the right. Otherwise, all the damages that were produced would be repairable, which is not the case. If we understand the right to reparation as part of a sequence in which it operates as a secondary right with respect to another right that is primary, then the right to reparation cannot be a right independent of others. I do not see how there can be such a thing as a right to redress that is independent of other rights, since redress is not a primary obligation. If I am correct, then the limits to reparation are not an issue that the legislator can treat as an optional matter of his jurisdiction. In this sense, reparation will be the consequence of having violated the limits of another right, the limits that should be previously determined by the legislator. What does comprehensive mean? there is an obvious tension between the freedom of the legislator to establish limits to this right and the idea that the reparation must be comprehensive. How would it be possible to have comprehensive reparation that can be limited by the legislator? It could be argued that the idea of comprehensive reparation refers to a conventional matter, according to which any measure of reparation that seeks to respond to the damage according to the law will be understood as comprehensive one. The problem with this interpretation is, however, that it renders the constitutional character of the fundamental right reparation irrelevant. The legislator sets out what is integral or comprehensive, which would be a petition of principle that does not leave any substantive content the nature of being comprehensive. When to apply some and not all measures of reparation? It is worrying that the court expresses that the legislator must respect, as part of the essential nucleus, the possibility that the reparation occurs by pecuniary and non-pecuniary means. The indeterminacy of the way in which the different pecuniary and non-pecuniary measures could satisfy this essential core is evident. What does it mean to leave that possibility of being repaired by both types of measures? It seems that leaving them as a possibility for the victim only indicates that they could not be prohibited, which does not clarify the picture very much, but rather leads to additional concerns. For example, it is not clear whether the legislative limitation to reparation measures is allowed with respect to non-pecuniary measures, as it happens with pecuniary ones. It is said that the legislative limitations are only applicable to pecuniary measures without excluding non-pecuniary ones, which does not help to the interpreter to determine if the legislator can prohibit some of them or if they remain outside the scope of the legislator. In my opinion, it would be reasonable to limit non-pecuniary measures too. At least one can think of types of limitation that select the measures that can be implemented for certain harmful events, as well as limitation of degree or intensity when certain types of measures are ordered in a specific case. If this were not the case, a public apology could be legally required due to a scratch on the paint of my car after suffering an involuntary traffic accident. The third indeterminacy is about the content of the repair. This final uncertainty regarding the essential content of the right to a comprehensive reparation is related to its purpose. The question is relevant insofar as it is not clear that the meaning given to the reparation is achievable, regardless the object on which it falls. The object of the repair should allow the sense in which it is implemented if it is insisted that the repair fulfills a specific purpose. In this regard, the doctrine sets forth that reparation aims to return things to the state they were in before the damage. Paradoxically, it is also admitted that this meaning is not possible on many occasions, as in the case of moral damage and non-pecuniary damage in general. Faced with this internal tension regarding the meaning of reparation, two types of responses are usually adopted. One of them appeals to the idea of compensation by virtue of which the object of the damage is not always repaired, but rather is replaced poorly or substituted by another that can provide some relief or satisfaction to the victim. On the other hand, a second type of response or interpretation advocates a sanctioning aim of reparation, assimilating the payment of compensation into a kind of private penalty in favor of the victim. Note that although the first response is the most backed in civil law, Colombian civil law, in both cases it is true that repairing implies something more than satisfying the aim of restoring a past situation. If the above is admitted, then the idea of reparation extends to the hypothesis of irreparability, in which is intended to respond to a situation where it is not possible to return to the past situation. Third, elements to determine the content of the right to reparation. In this final part, I want to highlight what could be the elements from which the content of the right to reparation may be specified, although accepting that an exact delimitation of that content is not possible before knowing the particular case. This specification will always start from a very high level of abstraction that will contrast with the specificity implied in the idea of an essential core. I think that we can try to determine the basis from which the content of this right could be specified, considering the indeterminacies we talked about before. That is, although it is not possible to build a specific core of the right applicable to every case, it could be possible to note that there are some grounds from which it would be possible to determine the boundaries of the right in any case. Of course, I don't intend to draw any conclusion about the contours of that essential nucleus in particular, but only to show some elements that would help in that determination. The first one is the universality of the right. Regarding the indeterminacy of the entitlement of the fundamental right to reparation, I consider that there are not sufficient reasons to acknowledge this right only to victims of crimes or violation of human rights. This idea represents a challenge that consists in elucidating an essential content of the right that is compatible with different branches of the law. That is, to achieve common basis for determining the content of the right that is common to the victims of wrongful harm, regardless of its legal qualification. But if someone insists on saying that this right is only of certain victims based on the differences between the behaviors that cause the damage, it could be considered that such differentiations do not necessarily demonstrate different kinds of harm. These differentiations make sense to show in the legal field how the different relationships between the group and the person or between the people themselves are expressed, but they do not seek to differentiate the status or aptitude of the victims to be entitled to fundamental rights, nor to modify the characteristics of the harm that may be suffered by wrongful acts. The drunk driver who commits at the same time a crime and tort against the victim causes the same damage regardless of which legal avenue, criminal or civil, causes its reparation. It should not be forgotten that the overlap between the damage produced in the criminal and civil sphere are not insurmountable. The damages that occur in different areas of law do not have to be differentiated by the sole fact of a different regulation of the behaviors that produce them. This is not always the case, as it happens with crimes against the public in general, but we must remember that we are talking about crimes that cause harm to a certain person. Furthermore, it is not strange to see proximity in the procedural field between certain criminal conduct that require a criminal complaint by the victim and that differ very little from the civil action that seeks reparation. The possibility of punishing the aggressor makes a difference, certainly, but in both cases, the availability of a claim and possible compensation for the damages is put on the hands of the victim. Another type of closeness in this substantial case occurs when a punitive interpretation of civil law, as is the case of some compensation ordered there, especially those dealing with extra patrimonial or non-pecuniary damage. Secondly, and not less important, it must be considered that although the non-pecuniary forms of reparation that form the essential core of the right have their genesis in international human rights, their implementation in Colombia has not been limited exclusively to these cases. Now, in the challenge of determining an essential content of the right to reparation, I would say that an answer for that challenge should highlight the very logic of a reparation as a right that reacts to the violation of or lack of effectiveness of another right. Under the logic of reparation, a legal response is provided to someone who has been wronged by another to whom that wrong is legally attributed. This proceeding seems to me to suppose a more basic idea than reparation, which is the recognition of the person who suffered the damage. And that idea can enlighten us about the most basic meaning of what we consider to repair someone. In that order, I would say that in any legal scenario, reparation supposes recognizing and treating someone as the recipient of a primary duty to refrain from wrongful harm, that is, as someone who is owed respect and to whom one must be accountable for the wrongful harm caused. As it is known, the violation of the fundamental right to reparation is not affirmed when the person who was damaged is not compensated for circumstances in which there was not a direct or indirect voluntary conduct, not necessarily intentional with precedence. This being the case, when it is said that one has a right to reparation, one is affirming that one has a right against another so that the other responds to one for all the wrongful damages that it produced and that are attributable to it. This idea of recognition enlightens us on the fact that if the existence of a fundamental right to reparation is defended on behalf of any person who in turn is entitled to other rights, it is because it is admitted from the legal perspective that the interaction in which the wrongful harm occurs between people who in principle are in context of equality. The expressive meaning of legal responses. Having said that, it could be affirmed that a fundamental right to reparation supposes an underlying and conditioning claim of the reparation itself, consisting of being recognized by others as a victim of a non-valuable event, either because of the conduct that preceded the interaction or the result of it, or both, depending on the argument the judges use. This reveals a clear expressive content of reparation, consisting of transmitting to the victim mainly, but also to society, that an event has occurred that should have legal reaction, an undesirable event that merits a respectful answer from the person who has wronged the victim. The way in which this recognition is expressed towards the victim allows the inclusion of measures that comprehend traditional monetary compensation to non-pecuniary measures, which allows that the expressive sense of the measure also may vary. In accordance with this expressive sense, it is possible to interpret those certain measures to have a greater or lesser expressive content. Thus, it can be interpreted that non-pecuniary measures of reparation are forms of explicit recognition of the normative position of the victim who was affected by wrongful harm. They clearly have a greater degree of expressiveness than the traditional monetary ones, since it is notorious that while monetary compensation transmits a message of recognition to another in a more implicit way, these non-pecuniary measures expressly recognize the normative status affected, and in that sense explicitly convey the message of respect for the victim within society. Thus, when one speaks in general of a right to reparation, one speaks of a recognition of the victim with which it is intended to protect him in such a way that the effects of the disturbance they suffer disappear, if possible, recognizing them in any case of implicitly or explicitly as someone who should have been respected. This interpretation allows other types of legal responses to be included within the idea of reparation that does not necessarily seek to return things to the previous state in which they were found, but rather to provide protection for the rights of the person through responses that recognize their position. Protected situation. The foregoing should not be interpreted as a disregard for the protected situation prior to the harm. It seems to me that whatever the thesis that is accepted, a right to reparation looks back to appreciate the altered situation and seek to deal with the new situation to positively affect the current state of the victim and their future prospects. This is the reason why theorists usually link the idea of reparation with corrective justice, which has that perspective on what has already happened. This does not mean that the reparation must occur in some corrective justice framework necessarily, but rather that it necessarily deals with something that happened before the interpersonal claim. In other words, the reference to the past forces us to duly explain and justify why there may be responses that, due to excess or defect, do not adjust to what happened or was altered. For example, if someone who crashes a vehicle is forced to pay a sum greater than the cost of repairing the damage, then the interpreter could reject this additional cost because it is not part of the way in which the fairness or of the repair is interpreted, or would have to give this a meaning that goes beyond the mere rebuilding of loss, arguing that it has a compensatory purpose that exists material damage, for example, or that it responds to a sanctioning sense, or that it serves to a sense of vindication. The need for this argumentation shows that the situation protected cannot be ignored by the legal answer provided to the victim, because that protection points out that the situation did not have to be wrongfully altered by anybody. Then there is a protected situation that should not have been altered in the first place, and this situation must be considered when giving content to the reparatory measures. Interpersonal respect. This inalterability of a legal protected situation is not intended to deny that accidental interferences in people's legal spheres may occur, but the fact that accidents happen does not imply that the reparation should be indifferent to the way in which the protected situation was altered. To hold someone responsible to some extent is to treat them as someone autonomous, and this implies that they are competent enough to be the recipient of a claim from another party. This makes it possible to show that it is not true that the recognition implied in the reparation must be necessarily be indifferent to the way the damage was caused. An accidental interference can give rise to a mere compensation for the material damage caused, but a vexatious or intentional attitude toward the victims does not have to be ignored when making reparation, for example, because it can cause greater non-pecuniary damage. The point I want to get to is that the practical respect owed to the victim can be not only a qualitative element that allows their understanding and justifies their implementation, but also an element that may have effects on the graduation and intensity of the measures, pecuniary or not, that are ordered as part of reparation depending on the case. 5, the context of interaction. One last point that seems important to me in determining the content of the right to reparation is the context in which the harmful interaction occurred. Obviously, appealing to the context does not say very much by itself, and so I would have to specify the relevant context to know what I am referring to. At this point, I can only suggest a context that seems to be relevant for the determination of reparation, which is the distributive context. The relevance of this context is evident to me in at least 2 ways. One that we could qualify as formal, according to which the reparation is due for the infringement of rights that were previously distributed or assigned in the legal order, and a material or substantive meaning or view which concerns the circumstances of the parties to the interaction. Then the distributive context would allow qualifying the reparation, but in conjunction with the idea of a harmful interaction, in which it is also pertinent to corroborate the due respect between the parties and the situation that was protected. In our legal system, the tendency has been to observe the distributive context from a formalist perspective. In this case, this context would be the same protected situation mentioned before. Nevertheless, there have been some judgment in which courts have adopted a substantive or material interpretation of the equality that should be involved in making justice for the case. For example, by adjudicating compensation for the loss of earnings for those who did not have a job at the time of the damage or other similar presumptions. Also, if interpreted materially, this distributive context can also lead to justifying other non-pecuniary measures to repair the damage, whenever it is very burdensome on the victim to assume compensation. As a conclusion, what has been said so far, it could be proposed that what is essential to the fundamental right to reparation is not a determined or delimited nucleus, but rather it is a construction that derives from some essential basis or foundation consisting of providing the victim with legal answer that imply the recognition as such, implicitly or explicitly, through pecuniary or non-pecuniary measures that take into account the state in which they were, due respect for their rights, and are appropriate to the context of the interaction. So the point is that the essential content of the right to reparation comes from the reasoning about these elements. It is important to analyze whether the reparation measure preserves, even minimally, respect for the victim and the recognition as such. If it protects the situation of the victim, and if it fits the distributive context of the interaction, interpreted formally or materially. This analysis will have to be done by the constitutional judge who guarantees the protection of the fundamental right for each case, considering that it is the law in general that provides answer to the wrongful harm and not just a branch of law. Thus, the detailed delimitations that are formulated ex ante on what is essential in the right of reparation are not plausible. First, I think that for the right of reparation, the establishment of insurmountable minimums cannot occur regardless of various factors that concern each case, to which I have referred before in a general way. So a forecast of how these factors will accommodate in each case seems unlikely to be possible, so clear rules cannot be drawn ex ante or applied in advance and to all cases in which reparation is ordered. Second, the establishment of precise rules on reparation affects the determination of the rights that are protected with it. So establishing an essential core for it is partially influencing the essential core of those other rights whose primary violation is answered by repair. To that extent, I would doubt that it was rigid or immutable content. In other words, I have preferred to argue in favor of certain elements that are basic when discussing the essentials of this right, rather than a firm conclusion about that essentiality. In this way, I have not wanted to establish conclusions on the substantive minimums whose transfer constitutes a violation of the right, but rather some reflective minimums that frame the argumentation to reach those conclusions in each case. In consequence, the logical thing to do would be to accept the existence of a dynamic or changing nucleus, but it seems to me that the idea of an essential content would lose its usefulness in a non-trivial sense, because after all, what is the usefulness of defending the idea of an essential nucleus when the essential content changes according to the circumstances at stake? Thank you very much.